Landlord-tenant law for the 2024 bar exam. First, let's discuss the Fair Housing Act. The Fair Housing Act, of course, prohibits discrimination in the sale or lease of property on the basis of R for race, C for color, N for national origin, S for sex, D for disability, and F for family status. The Fair Housing Act prohibits discrimination in the sale and lease of property on the basis of 6 things. They are 1, that's right, race. 2, that's right, color. 3, that's right, national origin. 4, that's right, sex. 5, that's right, disability. And 6, family status. What does this mean? You have children or extended family. R for race, C for color, N for national origin, S for sex, D for disability, and F for family status, meaning you have extended family or kids. Who is exempt from the Fair Housing Act? That's right, owner-occupied properties with no more than how many units? 4. Owner-occupied properties with no more than 4 units. Those are exempt. In Chicago, you are the owner and occupier of a 3-flat. You rent out the basement and the top floor. Are you subject to the Fair Housing Act? No. Why? Because you are the owner. You occupy it, and there are fewer than 4 units. Also, you are the owner of a single family home. Are you subject to the Fair Housing Act in renting that home? No. Owner-occupied properties no more than 4 units. Single-family homes fall into that exception. What if you use an agent to rent your home? Are you subject to the Fair Housing Act? Answer, yes. Why? Because the agent is advertising your home. Discriminatory advertising is always prohibited. So if you tell the agent, please do not rent to Hispanic or Latino people, you are out of compliance with the Fair Housing Act because discriminatory advertising is always prohibited. What about if we have the reverse? Annie owns a 3-flat and she likes diversity in her home. So she sends out advertisements saying that she prefers a Black couple with children. Can Annie do that and comport with the Fair Housing Act? No. Discriminatory advertising is always prohibited, even if there is no discriminatory intent. Okay, so far we have owner-occupied properties with no more than 4 units and single-family homes rented by the owner. They're exempt from the Fair Housing Act. The second you use an agent, Fair Housing Act kicks in. Can we ever have discriminatory advertising? No. Okay, what about roommates? Well, remember the roommates.com case? If you are renting a room in your home or advertising for a roommate, you have the right to choose with whom you will live. So, roommates, renting out your personal private room in your home, that is exempt from the Fair Housing Act. Additionally, final exception, Housing that's operated by a private club or religious organizations, and they only allow members to rent there, is exempt from the Fair Housing Act. So if we have a private club and they rent out housing or a clubhouse or a retreat, they're allowed to limit to their members. Okay, so the Fair Housing Act prohibits discrimination on 6 bases. 1, that's right, race. 2, that's right, color. 3, that's right, national origin. 4, that's right, sex. 5, disability. And finally, family status. What are our exemptions? Owner-occupied properties, including single-family homes, no more than 4 units and rented by the owner. Owner-occupied properties, no more than 4 units, rented by the owner. You use an agent, Fair Housing Act kicks in. Roommates. Roommates are exempted from the Fair Housing Act because one can choose with whom to live. And housing that's operated by, that's right, religious organizations and private clubs that just limit occupancy to their members. And what's always prohibited? That's right, discriminatory advertising, even if no discriminatory intent. Moving on to our types of tenancies. Term of years, periodic, tenancy at will, tenancy at sufferance. Term of years just is a term that has a definite beginning and end date. Although it might be a year, it might not. It is an express agreement in the lease for a definite beginning and end date. But if it's a year or more, what must it comply with? That's right, the statute of frauds. A lease, that's one of our MyLegs. Contracts for the sale or lease of land, or a contract by its terms that can't be completed within 1 year, are subject to the statute of frauds. So if the lease is for a year or more, it has to be in, that's right, writing, signed by the party against whom enforcement is sought. What does this mean? Can you have an oral lease? Yes, if it's less than a year. If it's less than a year, you can have an oral lease. Abe and Bob are landlord-tenant. Abe rents to Bob for 1 year. After 1 year, must Abe give notice to Bob that he is terminating the lease? No. When the lease is over, it's over unless Abe sends a notice of renewal. Okay, are oral leases less than a year valid? Yes. So therefore, what type of tenancy can be done with an oral lease? That's right, a periodic, example, month-to-month tenancy. No writing requirement unless the lease is for more than a year. For a periodic tenancy, do we need a notice of termination? Yes. A periodic tenancy continues indefinitely until the landlord notifies that it is terminating the lease. Repeat, a periodic tenancy continues until the landlord notifies the tenant that they are terminating the lease. If we have a month-to-month tenancy, does that lease have to be in writing? No, unless it is greater than 1 year. So if we have a year-to-year lease, it has to be in writing. Okay, so we said a periodic tenancy just continues on until the landlord terminates. The landlord has to give a notice to vacate. What time period at common law is required? That's right, the length of the tenancy up to 6 months. If you have a month-to-month lease, your landlord must notify you how many days before your lease terminates? 30 days. What if your tenancy is for a year? The notice to vacate equals the length of the tenancy up to 6 months. So Abe rents to Bob month to month. Abe must give Bob 30 days to vacate. Abe rents to Bob for 8 months. How many days or months must Abe give Bob to vacate? He must give Bob 6 months notice. Notice to vacate equals the length of the tenancy up to 6 months. Normally in a residential tenancy, 30 days notice would be normal. But in a commercial tenancy, the commercial landlord always must give 6 months notice. Commercial tenancy, notice to vacate, 6 months. Okay. A periodic tenancy is, of course, created by agreement, but it can also be created when the landlord accepts rent after the lease term. This is common law. If the lease is at an end and the landlord accepts rent, they have just created another periodic tenancy. Okay, tenancy at sufferance or a holdover tenant. Okay, so you've got a lease, it's been a year. Abe says, I think it's time to evict Bob. But Abe does nothing. Bob sends Abe rent for the next month. What just happened? He created a new periodic tenancy. For how long? 1 month. Once you accept rent from a holdover tenant, the landlord has created a new lease for that term. A new periodic tenancy for that term. Why? Because it is evidence of the landlord's intent that the tenant remain on the land. Once you accept rent from your holdover tenant, what happens? Landlord, you've created a new periodic tenancy because your acceptance of the rent signals your intent that the tenant remain on the land for the next period, however long. Okay, so in a tenancy at sufferance, we have, of course, our American rule and English rule. Of course, in America, we go by the English rule. The landlord's duty is to deliver possession and the right to possess under the English rule. The landlord must deliver what? Possession plus, that's right, the right to possess under the English rule. So if our new tenant comes in and there's a holdover tenant, what may that new tenant do? That's right, they can terminate the lease and sue the landlord for possession and damages. So under the English rule, the landlord must deliver what? Possession and the right to possess. And if they don't, the new tenant can terminate the lease, or they can sue the landlord for possession and, that's right, damages. Contrast with the American rule. The landlord delivers only the right of possession. That's right. So what happens when we arrive at our new home and there's a holdover tenant? The new tenant must sue to evict. American rule, new tenant must sue to evict. English rule, new tenant can sue the landlord for possession and damages or terminate the lease. Okay, so we just talked about tenancy at will and the landlord's duty to deliver possession under the English and the American rule. Let's talk about covenants and warranties and duties. What is the covenant of quiet enjoyment? Yes, no one will disturb the tenant's right of possession. In other words, the landlord is prohibited from entry. If the landlord enters, what may the tenant do? They can terminate the lease and seek damages. They can enforce the lease and seek relief in court. The covenant of quiet enjoyment means that's right, no one is going to disturb the tenant's right of possession. Who can never enter? That's right, the landlord, not even to make repairs. And what happens if the covenant of quiet enjoyment is violated? What can the tenant do? That's right, the tenant may terminate the lease and seek damages, or, that's right, enforce the lease and seek relief in court. Okay, our implied warranty of habitability. What is that? The landlord must provide premises that are fit for human habitation. That means they have what? Heat, air conditioning, plumbing, electricity. Can you ever waive the implied warranty of habitability? No, you can never waive the implied warranty of habitability, even if the tenant enters, takes possession of the apartment, and there's a leaky roof or a non-working refrigerator. It is the landlord's duty to repair. The implied warranty of habitability isn't waived just because the tenant enters and the premises are defective. Now, the tenant has to give the landlord notice of the defect and a reasonable time to repair, right? The tenant has to give 1, notice, and 2, time to repair. But what happens if the landlord doesn't repair? 2 choices. If we're going to act under the implied warranty of habitability, the tenant may withhold rent until repairs are made. Or they can 2, repair and deduct. Implied warranty of habitability, can it be waived? Never. What must the tenant do if there's a defect? Notice, reasonable time to repair. If that doesn't happen, tenant has 2 choices. 1, stay in possession and withhold rent. Or 2, repair and deduct. Okay. Everybody has the duty to mitigate. Any breach, both sides have the duty to mitigate. The landlord has the duty to mitigate if the tenant breaches the lease. The tenant has the duty to mitigate. Okay. If the tenant breaches the lease, the landlord has the duty to mitigate. How do they mitigate? Advertising the property, showing the property. What happens if the landlord does their due diligence and they do their absolute best to rent that specific apartment and they can't do it? Who's liable? The tenant. If the landlord did their due diligence, tried to mitigate, and failed, the tenant is liable for the remainder of the rent. On an MEE practice essay, there was a question in which the tenant breached the lease and the landlord advertised all vacant apartments. Did the landlord mitigate? No. The landlord must mitigate by advertising and showing that specific apartment. Otherwise, they have failed to mitigate. But if landlord does due diligence, tenant is liable for, that's right, the remainder of the rent due. What if the landlord mitigates and they find a new tenant? Is the old tenant completely off the hook? No. Mitigate means mitigate. The tenant's liable for 1, past due rent, and 2, any difference between the old and the new rent. Abe rents to Bob. Bob leaves unexpectedly after 6 months and breaches the lease with 6 months remaining. Abe mitigates. After 3 months, he's able to find a new tenant. Bob is liable for how much back rent? 3 months back rent. And what if the landlord, if Abe was able to rent, but he could only rent at a higher price? Bob is liable for the difference between the old rent and the new rent. Okay, duty to mitigate. Who has the duty to mitigate? The landlord and the tenant have a duty to mitigate. How must the landlord mitigate? That's right, by advertising and showing what property? That's right, that specific property. If the landlord does all that and can't find a new tenant, the tenant is liable for, that's right, all the past due rent. And if the landlord gets lucky and finds a new tenant, what's the tenant liable for? Any past due rent and difference between the old rent and the new. Okay, what can the landlord do if the tenant is in material breach of the lease? They're in possession and they refuse to pay rent. Well, the landlord can sue to pay rent, sue to evict, right? They have to give you your 5-day notice to pay rent or quit. Can they use self-help? Oh, no self-help, no breach of the peace. We know this. Okay, so our tenant's duties. The tenant has the duty to pay rent. So Abe rents to Bob for 1 year. Bob breaches the lease and abandons after 6 months. So landlord obviously has a duty to mitigate, but he can also simply accept the tenant's abandonment. He can accept the tenant's abandonment. He can say, Bob, see you. I accept it. You've abandoned the lease. If the landlord then takes possession, he has accepted abandonment of the lease. He accepted the tenant's surrender, and this does what to Bob's duty to pay? Bob's duty to pay is waived. If the tenant abandons, the landlord takes possession, he has accepted the surrender, and the tenant is relieved of the duty to pay. Okay, so what's not considered surrender? Just re-entry to repair or mitigating, trying to relet the premises. Okay, who has the duty to repair in a residential lease? The landlord. The tenant has the duty to repair only damages from the tenant's own negligence or anything else if it's agreed on in the lease. But under a commercial lease, who has the duty to repair? That is negotiable, but generally a commercial tenant has duty to repair. A commercial tenant is going to move in, and what are they going to do? They're going to install trade fixtures. They're going to paint walls. Now the commercial tenant decides to move. May they remove their trade fixtures? Yes. But what are they responsible for? Repair of any damages. So they can remove their trade fixtures, but they are responsible to repair damages. Okay, so remember our doctrine of waste, permissive waste, affirmative waste, and ameliorative waste, meaning improvements. The tenant cannot commit waste, any waste. But that also means that a residential tenant can't make improvements to the property without the landlord's permission. This happened to me in Chicago. Remember, Lisa, when you installed a dishwasher, you were making ameliorative waste. The landlord came over and said, I see you installed a dishwasher without my permission. The tenant has the duty not to commit any kind of waste, and that includes improvements to the property without the landlord's express permission. Moving on to disputes between the landlord and the tenant. Okay, the landlord is suing the tenant for rent. If the tenancy obviously the tenant has breached, the landlord can sue the tenant for rent, and they can also evict. Let's say the landlord is simply suing the tenant for rent. If the tenancy is for a term of years, we covered this. Abe rents to Bob. Bob leaves after 6 months. Lease is for a year. Bob is liable for all unpaid rent, and the landlord has the duty to, that's right, mitigate. So if the tenancy is for a term of years, the rule is tenant is liable for all unpaid rent, and the landlord has the duty to mitigate. Okay, periodic tenancy. Remember, a periodic tenancy, if it's less than a year, it can be created orally, and if it's breached, the tenant is liable for, that's right, unpaid rent until notice is given. Okay, I want you to remember one thing. For a term of years, when that term ends, does the landlord have to give a notice of termination? No. In a periodic tenancy, month to month or whatever, must the landlord give a notice of termination? Yes. So, tenant breaches, tenant is liable for all unpaid rent until they get proper notice. Okay, tenancy at will. We actually didn't cover this. Tenancy at will is just by agreement. So the tenant breaches. What's the tenant liable for? Just the amount that's already stated in the agreement, and that is owed. Okay, what about tenancy at sufferance? So we know what the holdover tenant, under the English rule, the landlord must evict the holdover tenant. The landlord must deliver possession. Under the American rule, the new tenant has to sue to evict the holdover tenant. But what about the holdover tenant's obligation? Tenancy at sufferance. Our holdover tenant is liable for what? The fair rental value of the property for the holdover period. Tenancy at sufferance. Our holdover tenant is liable for fair rental value of the property for what? The holdover period. Only exception. We have a holdover tenant. They're there a few hours and then they move out. Are they liable for those few hours? No. If the holdover period is minor, the holdover tenant does not owe anything. Tenancy at sufferance, minor, no liability to tenant. Tenancy at sufferance, tenant is still there. Tenant is liable for reasonable rental value of the property for the holdover period. Finally, last topic, eviction. Of course, we have actual eviction, legal or not, constructive eviction, and partial constructive eviction. Okay, so eviction can be legal, but more commonly on the bar, it's illegal. The landlord or their agent wrongfully tries to oust the tenant. What can the tenant do? Sue for damages and terminate the lease. That's right. Wrongful eviction, tenant may, 1, terminate the lease, or 2, sue for damages, or both. Constructive eviction. What is constructive eviction? The landlord substantially interferes with the tenant's right of possession. Wrongful conduct by the landlord that substantially interferes with the tenant's right of possession, such that the tenant has no choice but to move out. What does the tenant have in terms of rights? They can terminate the lease. They've been constructively evicted. The tenant must move out. To allege constructive eviction, the tenant must move out. What is constructive eviction? That's right. Wrongful conduct by the landlord that substantially interferes with the tenant's right of possession such that the tenant has no choice but to move out. They've been constructively evicted. If you want to use constructive eviction as a defense, you've got to move out. What about a partial constructive eviction? So, partial constructive eviction might be due to conditions, and if so, the tenant is entitled to a rent abatement. Actual eviction, if it's wrongful, what does the tenant get? Damages, and they can terminate the lease. Tenant alleges constructive eviction. What must the tenant do? Leave. Partial constructive eviction. Conditions are such that it is almost impossible to remain there. The tenant is entitled to a rent abatement. That's right. And that's it for landlord-tenant law.